This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, Todd Lutsky from Cushing & Dolan joins us now live on air. It's your chance to ask him your estate planning questions live on air, which is why we call the segment Ask Todd. Studio lines are open at 888-205-2263. That number again is 888-205-2263. Usually can get through 2 to 3 calls, so get calling early and often if you want to make sure we get to you. Again, that phone number is 888-205-2263. One more time, it is 888-205-2263. Mr. Lutsky, how are you doing today?
I am never better. How are you?
Not great.
No, it's always something with you.
Well, wife says she's considering a divorce because I care more about sports than our marriage.
Oh, yeah? Well, do you?
Well, here's the thing. We almost made it through 7 seasons.
That's true.
So there's
not
that.
bad. Yeah,
there's that. Todd, I want to talk to you a little bit about what's going on when it comes to estate planning and estate taxes. How do trusts help to mitigate issues with estate taxes, either at the state or federal level?
So it's funny. I was just meeting with a client, and they're always wondering, we always hear that we should be doing this. We hear it, but we haven't done it. You know. And these folks come in and let's say they're worth, it's about $18 million. Well, yeah, we should be doing it, right? And remember, it's giving away free money if you don't do your planning is really what it comes down to. And you're making a gift to the state in a lot of ways. So that's the first much is taxes. That's what you're asking about. So now, federally, for a lot of people, it might be, well, no, it's not a big deal, right? Because the federal exemption is at $13.9 million. It will soon be $15 million come 2026 under the new act that passed. But who knows? It's not permanent. We have a new president in the future. A new regime, it could lower the exemption. It's been all over the map. So you always got to be planning for whatever that exemption is to take advantage of it, because you never know what it's going to be when you die, but you want to make sure you get it and use it. And by the way, these exemptions are the amount of assets you can pass estate tax free. Go over this number and you got to pay taxes. If it's to somebody other than a spouse. You can leave an unlimited amount to a spouse, which of course is what they want you to do, because if you don't do planning and you die and you have everything jointly owned with your spouse, everything just passes to your spouse. Hey, that was easy. Yeah, but now your spouse has all the assets and it might be larger number than that spouse's exemption, and they don't mind waiting and they get to pay the tax on the survivor's death. So always want to grab whatever the exemption is on the first death to shelter as much as you possibly can. When I say shelter, it means whatever's in the trust, back to your point, Chuck, whatever's in the trust that's potentially taxed on the first death will not be taxed when the survivor dies. That's how we shelter it, so there's less taxed when the survivor dies. And on the first death, it's always designed to never exceed, the shelter never exceeds whatever the exemption is. So there's never going to be any tax on the first death. Now, having said that, federally you might be saying, yeah, Todd, so what? It's a big number. What about Mass? Massachusetts only has a $2 million exemption. You could have your home alone could be $1 million, right? You could have a life insurance policy for $1 million. You're at $2 million and you have only talked about 2 items. So it sneaks up on you, right? So at some point you have to realize the trust will also shelter the same way I discussed it for Fed. It shelters for Mass, the $2 million, so that the survivor, if they're worth less than $2 million, no tax. So on a $4 million Massachusetts estate, more reasonable, right? More like, hey, that's me. I can eliminate Mass tax with basic estate planning using trusts on $4 million. So there are good reasons to do it, Chuck.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. This is your chance to ask your estate planning questions live on air right now. Phone lines still have some room at 888-205-2263. That number is 888-205-2263. We're going to take a quick break here, but when we come back, it's going to be right to your questions with Todd Lutsky. Again, still a little bit of room, so get calling at 888-205-2263. One more time, that number is 888-205-2263.
Miss any of the show? The Financial Exchange Show podcast is available on Apple, Spotify, and iHeartRadio. Hit the subscribe button and leave us a 5-star review. This is the Financial Exchange Radio Network. This is your home for the most comprehensive coverage of the economy and the trends on Wall Street. This is the Financial Exchange Radio Network.
Alrighty, as promised, let's get right to your calls for Todd Lutsky. First up, we've got Phil on the Cape. Phil, what's your question for Todd?
Yes, Todd, more than 5 years ago, you made a irrevocable trust for me. And now my question is, if I get cryptocurrency or gold bars, can I put that in the trust, or do I have to make a new trust?
So I'll answer it this way. Yes, you can put any kind of investment you want into these trusts, whether it's gold, crypto, stocks, bonds, real estate. It can be added to the trust, titled to the trust. I do that for almost all assets. I help you do that. So it will create a new 5-year waiting period, but only for the new addition that you're putting in the trust. It will not affect what we did 5 years ago. My last caveat to your question is, well, yes, you can put crypto and gold in there. I am not sure how you transfer crypto to the name of the trust. But if you're involved in crypto, maybe you know how, and we can get whatever paperwork you need together to do that. And so that would be the answer. So, yes, go ahead and contribute. And, folks.
Okay, but it's
Yep, go ahead.
You definitely have to put in a new 5-year waiting period.
But only for the
Not
new
the
edition.
same.
Only for the new edition. Okay? Excellent. And so, folks, that's just, and again, he's got the irrevocable trust in place, which is great. He's beyond the 5 years. That's just one of the trusts that we're talking about in our guide this month, which is the top 7 estate planning trusts. I've sort of over the years thought about what these are that I see most of the time, and I put together this guide. It tells you not only how they work from an estate tax standpoint, an income tax standpoint. They're irrevocable, they're revocable trusts in here. Medicaid, like the one Phil has, an irrevocable trust that protects from nursing homes. There's, special needs trusts if you have special needs children. There's even the dreaded nominee realty trust that a lot of people have but really don't understand because it's not really a trust. And it also explains the day-to-day operations of how they work to not, encumber your life in any way. So if you haven't gotten started in estate planning, this will help you get started. If you've gotten started, maybe you want to adjust the kind of trust you have. Something for everyone in this guide, folks. Call and get it, 866-848-5699 or legalexchangeshow.com. Again, top 7 estate planning trusts, 866-848-5699 or legalexchangeshow.com.
Let's stick with the Cape. Let's go to Dave on the Cape. Now, Dave, what is your question for Todd Lutsky?
Hi, good morning, Todd.
Hi, Dave.
I've got my wife and I have several $1 million in IRAs. What's the best way to protect that and pass it on to my kids?
So as a percentage of your overall estate, let's say several means 3, of your overall estate, how much is the IRA? Like, if you're worth $4 million, most of it's an IRA. That's what I'm trying to find out.
Yeah, the majority. I've got $5 million in IRAs, and my real estate equity in 2 houses is a little over $1 million. And
So-
that's like 95% of
Of your assets.
besides equity in the house, 95% of our investments are in IRAs.
So $6 million estate, and how old are you?
63.
So your question is, how do you protect it from a nursing home?
No, I just like, what's the best way to pass it on to my kids?
Yeah, great question. So, and I agree. I don't think you need to be worried about nursing homes. I think you're probably self-insured when you talk about investing $5 million. The income that it generates alone will be helpful. But estate tax-wise, yes, we got to avoid probate. We want to reduce significantly the mass estate tax, at least. Federally, you're fine. And so then the idea is, how do I leave this to them? Probably in your case, a revocable trust. Put the houses in now. Put the bank accounts in now. Leave the IRAs out for now. The designated beneficiary would be each other. And then the contingent beneficiary would be the new family revocable trust that we put together. So that ultimately this $5 million will get into the trust. Yes, it will shelter, allow us to shelter assets for estate tax purposes, at least for mass. Federally, again, it's doing it, but it's not critical. Depending on exactly how much we can get into the trust while you're both alive, we may need to direct some of the first to die IRA to the trust rather than to the spouse. But that's something we would fine tune when we're together, or whenever you're working with whoever you're working with in the estate planning attorney world. You would fine tune that. But the beauty is, not only does it avoid probate and help you shelter the estate taxes, but with that kind of money, you can design the trust so that when you die, the assets are going to be sheltered for your kids from future creditors, future divorces. I mean, this is a big enough dollar amount that you might want to think about doing that. And so the trust can live on even after you die and really provide nicely for your family. So great question, and I think you're on the right track, but I do think you need to do some planning to save the taxes.
Got another one for you here, Todd. Let's go to Dale in Newberry. Dale, what's your question for Todd Lutsky?
Good morning, Todd. I'm 75. My wife is 62. We have a house paid for worth about $1.2 million, and we have $1 million in IRAs. My question is, am I in the need for a credit shelter trust?
So you're when you say, so let's look at $2.2 million estate, right? Well, Massachusetts, remember, is only a $2 million exemption. So yeah, I mean, I would want the credit shelter if I'm going to do a trust for you anyway, right? Which I'm going to ask you another question in a minute. But if I was going to be doing a trust for you anyways, I would want that trust to include credit shelter, Q-tip language, so that, again, 75 and 62, there's a long time before both of you are gone. And we want to make sure that on the first death, we shelter what we can, so there's no, not just reduced, but zero mass estate tax. So that would be yes on a credit shelter trust. And then lastly, I would just think about, well, if you both have kids or you're trying to leave assets to the next generation, you might want to think about the type of trust you do, which might be irrevocable if you want to protect the house from the nursing home, and maybe even some of the IRA from the nursing home a little longer. I don't have a discussion for that now, but there's a way to do both. I would think the irrevocable trust approach would be right for you, and yes, that trust would include the Q-tip language, so you can get asset protection and estate tax planning at the same time. So yes, you're on the right track as well, but I think you need to seek out a lawyer to get it done.
Todd, I got one more for you. We're going to have to be quick, but Peter in Worcester, what's your question for Todd Lutsky? Only got about a minute.
All right, Todd, thanks for taking my call. Real quick, I have a revocable trust. I'm 65 years old. I have two children that are basically named as in the will and the trust.
Mm-hmm.
My question to you is, I have a 457B plan that I was instructed by my lawyer to put into the trust as a beneficiary. The trust is the beneficiary for my two daughters.
Got it.
My question to you is that okay, or should I just basically name my two daughters as beneficiaries?
Here's the answer is really going to be up to you, and here's why. If you are saying, Todd, I'm okay with my daughters taking the money as they want to take it from over 10 years, just name them. If it's a large enough number and you're saying, I also want to make sure it's protected from creditors, future divorces of the kids, etc., then name the trust and have that language built into the trust. So it's really up to you how much it is and how much protection you think you really want for your children. So hopefully that answers the question, and I think we're out of time.
Mr. Lutsky, thanks so much for joining us.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.